Certainly, Your Honor. And I would add to the record that this is a agreed-upon disposition in lieu of indictment. Counsel and I have been discussing disposition for some time and agrees what we think is a reasonable resolution of this case. If this matter would go to trial, the Commonwealth will produce the following facts. And I'm reading from the report of Sergeant Matthew Murphy of the Massachusetts State Police. December 15, 2009, approximately 4:30 p.m., members of the State Police assigned the Middlesex DA's office executed a search warrant at 43 Pleasant Street in Air. Not going to announce their presence. The defendant from the court called, answered the door. They identified themselves. He was invited. The police were invited in. The defendant was provided a copy of the search warrant. It was time to review the search warrant. The police officers indicated the purpose of their visit. Say they were investigating information that they had received through their investigation, and in particular, variety of information, computer usage information. The officers asked Mr. Cole if he was using file sharing software on his computers. Mr. Cole indicated that he was. Mr. Cole then invited the troopers upstairs to talk privately. At the time, the Middlesex DA's office troopers and the Air Police Department began to conduct a search of the premises under the warrant. Mr. Cole was told that he wasn't under arrest. He did not speak with the police. In any event, Mr. Cole indicated that he understood and said that he would answer questions by the police. The conversation was recorded with his permission as well. In brief, Your Honor, Mr. Cole told the police that he worked at a pharmacy for the Veterans Administration. He told them that the laptop in the living room was his. There was a desktop computer in the living room that had been used for years, and there was also a desktop computer in the bedroom of the home that had been used for about 5 or 10 years. Mr. Cole indicated that he was providing internet service in the home through Verizon, and it was a network cable type of service. Cole indicated that he owned all the computers, and he was the sole person in the household that would use the computers, although his parents also lived in the home. Mr. Cole indicated that he used them for games, emails, and Craigslist. Mr. Cole also indicated that he used a file sharing network. He wasn't exactly sure the name of the program. Eventually indicated that it was a BearShare type of program that allows users to download or interface with other similar computer users. In particular, eventually he indicated that he was using it and had downloaded child pornography on his computer. Cole indicated that he would see a file that he was interested in, and he would browse the host file to see what files were there. Cole indicated that he would automatically keep all those files in a particular file in his computer. From time to time, he would clean it out and then get new stuff in it. Cole admitted that he would separate the downloaded videos and pictures into different folders, identify himself as somebody who was in possession of child pornography, admitting to using a P2P or peer-to-peer network to obtain and/or collect child pornography, admitted to moving the child pornography, at least within his computers, in the shared peer-to-peer folders. And those folders were entitled pictures, videos, etc. Eventually, following the execution of the search warrant seized the computers, digital forensic investigator Melissa Marino, the DA's office, conducted a forensic preview of the laptop found in the living room, which the Cole indicated was his. The preview revealed that there were multiple images, still images, and video images of child pornography. That is, children visibly under the age of 18 engaged in sexual activity. Those images and videos were found on Mr. Cole's laptop. Further forensic preview of the other two laptops, the one found in the living room and the one in the bedroom, revealed multiple images and videos of child pornography. Again, children visibly under the age of 18 engaged in a variety of types of sexual activity. These previews of the 3 hard drives additionally confirmed that the defendant was storing at least 200 more child pornographic files on the computers. Cole was placed under arrest and advised to defend the rights. Cole was then transported to the police barracks and necessary for processing. At the station, he agreed to speak further with the police. Investigator Marino and Trooper Macy State Police conducted another recorded interview of the defendant. While being recorded, Cole was again advised of his Miranda rights, agreed to speak to the police. Told the investigators that he believed there were about 70 pornographic files of boys on his computer. They used the Bearflex file sharing software and never shared his files with anyone else. Cole said the youngest of the boys portrayed in pornographic child pornographic file stored in his computer was 10 years old. Cole said that the downloaded Bearflex software allowed him to get the images and videos onto his computer. He said that he does delete items from time to time, but will continue to use the software to gather new ones. The most recent time that he had gathered new ones was about 6 years prior to the execution, 6 months prior to the execution of the warrant. Mr. Cole said that he wasn't sure of some of the search terms that he used to find child pornography on the internet using Bearflex, but he identified them as P or HC something, and the troopers would indicate that PTHC refers to preteen hardcore, a common name used in the titles of child pornographic files on the internet. Cole also stated that the purpose of his views is to pretend that he is young. Cole said that he no longer looks on the internet for child pornography since he last downloaded Bearflex. Cole also acknowledged all the computers were his, added that he never joined any child rooms. Those would be the basic facts of this matter of trial.
And we have 3 proposed conditions of probation, which were signed by both lawyers and himself. His probation, as soon as we made aware of this.
Yes.
They're very lengthy. I'm not going to read them, but we submitted for a file.
I have additional copies, Your Honor, for his probation.
Oh. All right, so I ask some questions for you before I accept your guilty plea. I want to make sure that your guilty plea is voluntary and you are aware of the consequences of your guilty plea. How old are you, sir?
15.
And what is your education? How far have you gone to school?
High school.
Have you been employed?
Yes.
What have you done for work?
I've been in the Air Force and I work for the Veterans Administration.
Have you had any drugs or alcohol or medication in the past 24 hours?
No.
Have you ever suffered from any mental illness that would impair you today?
No.
So you are giving up some important rights by this guilty plea. You're giving up your right to have a trial. The trial in district court is before a 6-person jury or before a judge. Jury trial in district court, as I said, 6 residents of Middlesex County. You can assist your lawyer in selecting your jury from the Middlesex County residents who come to this courthouse for jury duty. The jurors, after they're impaneled and sworn, hear the testimony against you. You must reach a verdict as to whether you are guilty or not guilty, and the verdict must be unanimous. All 6 jurors must agree on the verdict. Do you understand that, sir?
Yes.
As I said, you could also elect to have a trial before a judge. Trial before a judge is called a bench trial or a jury waive trial, and that is where a judge alone hears the evidence and decides whether you are guilty or not guilty. Do you understand that, sir?
Yes.
Whether your trial is before a judge or before a jury, you have certain constitutional rights that you give up when you plead guilty. I'm going to go over those rights with you now. You're giving up your presumption of innocence. You are presumed innocent of this offense unless and until the prosecutor proves you guilty beyond a reasonable doubt. Do you understand that?
Yes.
You are giving up your right against self-incrimination. You do incriminate yourself today by pleading guilty. In a trial, however, you would not be required to testify against yourself. You would not be required to produce witnesses or evidence unless you chose to do so. You understand that right for the giving up?
Yes.
You're also giving up your right to confront your accusers in court. That is through the lawyer's cross-examination of the Commonwealth's witnesses. Do you understand that right for the giving up? Has anyone forced you or threatened you to give up your rights and to plead guilty?
No.
I also want to state, sir, that you're giving up your rights to file any motions to suppress evidence or to dismiss the case. Do you understand that?
Yes.
You've gone over this screen sheet with your attorneys.
Yes.
Do you understand what's on here? Satisfied with your lawyer's advice?
Yes.
And counsel, you satisfied that your client understands the elements of the offense?
Yes, Your Honor.
You heard the evidence the prosecutor recited a few moments ago, sir?
Yes.
Is that a fair description of what occurred in this case?
Yes.
Sir, I am required to tell you that if you are not a U.S. citizen, this could cause your deportation, denial of admission to the United States, or denial of naturalization as a citizen. That probably doesn't apply to you, but I am required by law to tell you that. Do you understand that?
Yes.
And you have gone over and read the probation conditions, so we're not going to recite right now, but one of those conditions is you are required to register as a sex offender. You understand that? Anything else from the board?
Yes, Your Honor, if I may, just a couple of sort of housekeeping things may file the note of return bail, Your Honor. My client is out on bail, may file in bail return. And also, a couple of things on the MIT, Your Honor. My client served 3 days prior to making bail, so the MIT is like 3 days credit.
Is there any...
We're in agreement with that, Your Honor.
3 days credit. Also, I did notice his medications.
Right.
I can't take them with him, but they'll be noted on the minutes.
Yeah, that's why I submitted that to the court.
Right. All right, there is a factual basis of your guilty plea. I'll accept the joint recommendation.
I'll move for sentencing, Your Honor.
Okay. And it
2.5 years, read 15 months to serve, balance suspended 5 years, with standard conditions of probation, as well as the document before you with specific conditions of probation in this case. That is on count 2. Count 1 is dismissed. So it's 30 months in house correction, 15 months to serve, balance suspended for 5 years, probation correcting. And the agreement attached to the agreement sheet, so we have it provided. Supervised probation upon release, so it'll be $65 per month. And the victim of the state.
As to complaint number 0938CR1851, count 1 stands dismissed upon request of the Commonwealth with your consent. Count 2, the court finds you guilty, sentence issued is 30 months in house of correction, 15 months to serve. The balance is suspended with probation for a period of 5 years, that's until June 24, 2015. You're to be given credit for the time that was held. The $50 victim witness fee on count 2, and upon your release, this is $65 per month probation supervision fee. There's also a list of probation conditions, and the list of medications will be attached to the MIT.
In custody?
Thank you, Your Honor.
Just for a quick moment, it's 5 hours.
Very brief.